Hello friends, welcome to Happy Institute YouTube channel. Happy Institute is one among the leading institutes imparting training in stenography. The institute in the last 35 years has helped hundreds of aspirants of government jobs in fulfilling their dreams. Students of this institute have secured top ranks in various All India competitive exams held by UPSC, SSC, DSSB, IBPS, and other recruitment agencies and are working in almost every department of Government of India, be it Ministry of External Affairs, Railway Board, Home Ministry, Election Commission of India, Income Tax Department, CBI, and other prestigious organizations like Supreme Court and High Court. We also publish happy speed dictations for developing speed with passages meticulously selected from latest topics with practical phrases and simpler outlines. This book has become the most prominent choice of almost every reputed institute, teacher, and student of stenography in a short span of time. The proof of its popularity is that in the last 3.5 years, more than 25,000 copies have been sold all over India. We have now launched a series of legal dictations to help aspirants who have to appear in skill test of Punjab and Haryana High Court on 27th February 2022. The dictation is released every day at 1 p.m. on Happy Institute YouTube channel. The students are requested to write and transcribe this dictation and compare with the original passage given in the description more than once if required. Please like and share every dictation that you write and subscribe to Happy Institute YouTube channel. Get ready for dictation, please. 5 seconds. Start. Since there is a non-obstante clause even against the Transfer of Property Act, therefore, if a person enters into a property as a tenant without a written agreement to that effect, then such a person does not get any legal right qua such property. In absence of written agreement, landlord shall not be a statutory landlord under the Act, and the tenant shall not be a statutory tenant. The status of such a person shall not be even of permissive possession. Such a person shall not be more than a rank trespasser. He shall not be entitled to any kind of protection or defense against the landlord. However, the landlord shall still be having full ownership rights over such property, including his right to uninterrupted possession to the property, being a lawful owner. Hence, the landlord shall be fully entitled to ask such a person to vacate the property, and if not so vacated, to throw out such a person without recourse to any legal process. Even if the landlord takes recourse to a legal process, then the court shall also be bound to order restoration of possession without entertaining any defense on the part of any such alleged tenant. Hence, it is only with a written agreement the tenant becomes a statutory tenant under the present Act, and the landlord becomes a statutory landlord under the Act, and both are to be governed by the provisions of the Act, making them entitled to some legal rights and subjecting them to certain legal liabilities. Subsection 2 of Section 4, which requires registration of rent agreement, also starts with a non-obstante clause. However, this non-obstante clause is made operable against all the provisions contained in the Registration Act. Before the amendment of the year 2014, even the authority where the rent agreement was to be registered was specified to be the rent authority itself. The authorities under the Registration Act had no concern with the rent agreement. Hence, it was not a document compulsorily registrable under Section 17 of the Registration Act. Rather, due to non-obstante clause, it was registrable only under Section 4 of the Punjab Rent Act. The provision of Section 4 as amended by the Amendment Act of 2014 prescribes that the rent agreement under the Act shall be in the format specified in the schedule to the Act, and the same shall be registered under and in accordance with the provisions of and with the authorities prescribed under the Registration Act. However, the fee to be paid for such registration has been specified by the provision of Section 4 itself. Hence, it is clear that while subsection 1 of Section 4 overrides Section 107 of the Transfer of Property Act, subsection 2 is enacted in the nature of overriding the provisions of the Registration Act 1908, except to the extent of same being saved by the language of this very subsection, that is, regarding the authorities with which and the manner in which it is to be registered.